are trying to bring the world, the contemporary world, into the law school, and also bring the law school and our fabulous scholars and teachers out into the world. Today we have Professor Jocelyn Simonson, who's going to talk to us, as you know, about what comes after money bail. Let me tell you just a tiny bit about Professor Simonson. She joined the Brooklyn Law School faculty in 2015, where she has been an innovator, a scholar, a teacher. She's co-director of the Criminal Justice Center here at Brooklyn Law School. She's written a number of articles that have made a big splash out in the world about bail, about cop watching, drawing on her both theoretical interests and her practical experience for many years in the Bronx Defenders. And so she's a fabulous marriage of knowing the real world, caring about the legal systems, infused with a passion for justice, and is going to talk to us today about one of the top contemporary issues that we're all thinking about and hearing about. Our thought is that Professor Simon is going to start with a few slides and then going to talk, and this will move into a discussion with time for questions and comments after the formal beginning. So, take it away.
Great. Hi, everyone. Thanks for coming. So I have slides. No one should feel like they need to see the words or read the words. Mostly they're images and some charts to sort of just set the scene a little bit. A lot of you, especially looks like in this row, are total professionals in everything I'm going to talk about because they just took Crim Pro with me. But some of you might not know that much about money bail. So I'm going to sort of try to set the scene a little bit. And again, don't worry too much if you can't see. I want to talk today about bail in New York, in part because we are going to have bail reform in New York this year, probably, maybe. And so it sort of sets the stage for a clean slate to think about what should the pretrial world look like when someone's arrested and charged with a crime. This is I will read it. This is a title from the New York Law Journal. Criminal justice reforms more likely in New York as Democrats take office. So I have a picture of Cuomo, our governor, our newly elected Senate Majority Leader in the state Senate, and activists who have been working tirelessly for years to both elect new legislators and push for bail reform, among other things. But I also blew up a little bit the tiny words. As is often the case in Albany, any reform will be negotiated based on the finer details surrounding the issue. So I want to talk a little bit about the finer details and rather just sort of the words bail reform always meaning a good thing. They don't always mean a good thing, no matter what your beliefs are, because they can mean very different things. This is a chart just to show how many people are locked up in the United States totally. It's from the Prison Policy Institute. A lot of the next charts are. So if you can generally see the circle, the teal is the 1.3 million people who are in state prisons throughout the country at any given moment in time. So this is not cumulative. It's any given moment. And the orange is the approximately 615,000 people who are held in local jails every year. And it's probably at least a dozen that per year, if you look at the whole year. But this is at any one time. And so when we talk about bail, we're talking about that orange slice. We're talking about people who are in pretrial detention. Let me just, and if we go forward, this is that orange slice. If you look at people who are in jail, up here is the slice of people who are in jail but not convicted. So that's about 465 or 460,000 people at any one time. And this is just state courts, but state courts are the vast, vast, vast majority of all criminal law. So if we look at those 465,000 people who are not convicted, 8 out of 10 of them are there being held in a jail because they've been charged with a crime. Could be a misdemeanor, could be a felony. They're presumed innocent. They haven't either pled guilty or had a trial yet, but they are awaiting the end of their case from inside of a jail because bail has been set in their case, money bail. Bail can mean a lot of different things. When we talk about money bail, it means a judge has said, I am requiring that you or someone in your family or someone you know, or maybe strangers who are part of a community bail fund, pay bail in a certain amount in order for you to be released. And if you come back to court, then you will get that money back. That's a traditional way. It varies in about 39 different ways, I think precisely 39 different ways throughout the country. But that's the general idea of it. And so when we look at that 465,000 number, that's people who are in jail, haven't been convicted of anything, and cannot pay the amount of bail or bond that's been set, whether individually or through a bail bondsman. When we think about New York or mass incarceration more generally, because we sort of want to situate it within that, if we look at incarceration rates, the idea of this chart, again, you don't have to see the small numbers, is that the big line on the top is the United States rate of incarceration per capita compared to other NATO countries. I guess, well, we're still in NATO, we're there. And below that is New York. So we're going to talk about New York. New York is better on average than the rest of the country if you're worrying about mass incarceration rates per capita, but it's still very large. Here's the same charts again. I'm just doing this quickly to show that the orange to teal to yellow is the same in New York as for the US, okay? So on the right in New York State, about 27,000 people are in local jails at any given moment, and that's a similar slice of the pie of who is incarcerated. Okay, so I just talked about this a little bit, but how you end up detained pretrial, only one of the ways is that you're there because you can't afford money bail. So some of those other parts of the chart might be that you have a warrant out somewhere else, or perhaps you are serving a short sentence. If you're sentenced to, say, 30 days in jail, you're going to be sentenced in a local jail rather than a state prison. And the bottom left is a chart just showing that when we look at the rise of jail populations over the last few decades, by far the biggest rise has been in people who are not convicted and are in jail. In other words, people who are there because they cannot pay bail. There are also racial and ethnic disparities. This is for prisons and jails in New York. The chart looks very similar, but just didn't look quite as pretty for bail. So on the left are, and again, you don't have to worry too much about the numbers, on the left are the percentage of the population of various demographics, and on the right are the prison and jail populations. And in New York State, 58% of the population is white, but there are only a quarter of people in jails and prisons. And for black New Yorkers, it goes the opposite way. This is, I don't know if anyone knows this, but now we're getting even shorter. In New York City, at any time you can go online and look at who is in our New York City jails right now. So I did this yesterday, and it fetched the data from Monday. So let's assume this is still the case today. Oh, it's probably not. People are going in and out. As of this week, there are more than 8,000 people in New York City alone who are in our jails. That's about twice the population of Staten Island. And if we look at this circle, 67% are there as a detainee and not being held for another reason. So why are they there? They're there because bail has been set and they can't pay that bail. So that's 5,480 people right now. Many of them are on Rikers Island, but not all. These are the demographics of those people. Up high, the blue is male, so 93%, or at least are designated male by the city. And then on the bottom right, 55% are black and 11.5% are white. For comparison, about 45% of residents of New York City are white. Here there are some words, but I'm going to tell you about them. So, why is it a problem? One problem might be because there's a presumption of innocence and we don't think people should be in jail because it's a kind of punishment. That might be one argument. There's also an argument being made that being detained pretrial actually leads to harsher punishments. And so we can think about why. But studies have taken cases where people are charged with the same thing, have the same criminal history, are in the same courthouse, and sometimes even, hopefully for a perfect study, are in front of the same judge, and find that if bail is set, then if if someone ends up getting less than a year sentence for jail, they are 4 times more likely to be sentenced to jail if bail has been set than if bail has been not set. And when they get a jail sentence, their jail sentence is likely to be 3 times as long as someone for whom bail was not set. And that is holding everything else the same. Similarly, with prison, it's 3 times greater likelihood of being sentenced to prison, so that's probably going to be more serious cases, like felonies, and twice longer prison sentence. Why might that be? Again, I have some professionals here, but I will just quickly give a few reasons. One is that we'll talk about the jail one for a minute. If someone's being held in jail pre-trial, they are not home, right? So they can't work, they're not with their family, they are going to lose possibly their car if they can't make certain car payments, their children might be taken away. And so if somebody comes and says to someone who's been arrested, you're incarcerated, you're presumed innocent, and you can go to trial. But if you go to trial, you're going to have to wait for trial while you're detained here in jail. Or you can plead guilty. And possibly go home, and probably go home. And so many people make that choice to plead guilty and go home, and that is why there's a greater likelihood of being sentenced to jail. But in addition to, say, not being able to see one's family, you don't get to talk to your lawyer as much, you don't have as much access to the resources that you might need to fight your case. So that's one way of thinking about the price of not being able to afford bail. Pretrial detention is also very, very costly for cities or counties or jurisdictions who detain people. So it's about 20 times as expensive to hold someone in jail than to, say, pay a probation officer to supervise them, and it's even less if you don't do that, if you just release them. So this sort of gets to what's the problem with money bail. It's an important question to ask, because what we do if we don't like money bail, and let's face it, we're getting to a pretty big consensus that money bail as it is now doesn't quite work. So even the New York District Counties Association, which does oppose most proposed reforms right now, starts out its press release saying, we acknowledge the money bail system isn't working, right? So it's a lot of people start out that way. The one exception, anyone guess the one exception to that? The bail bonds industry. The bail bond industry, yeah. They think it's working fine. So what's the problem with money bail? This is not a word slide. I have sort of 3 pictures that might bring up 3 different ideas of what the problem is. I'll start on the right with Harvey Weinstein, who's been charged with very serious crimes, but is not incarcerated pre-trial. So his bail was set at $1 million. Most people could not afford that. He clearly can. And so he's not incarcerated pre-trial. Some people see that and think that's not fair and just. But why is it not fair and just? Maybe it's because we think that he should be incarcerated because he's charged with something bad. Maybe it's just about him. But a lot of times it's about a comparison. Meanwhile, someone charged with a low-level crime and bail is set at $100 might be incarcerated. Maybe it's because he's white, and so we're worried about racial disparities and how people are treated. Maybe we don't think it's a problem that he's out, because there's no allegation that he's fled the jurisdiction or committed another crime or anything that we might be worried about, right? Or we might think about Kalief Browder. This is a case that we talked about a lot in my class. So Kalief Browder was on Rikers Island, detained pretrial for 3 years, And he started out there, although the whole time was not on bail, with bail that he could not afford. And he was charged with a serious felony for allegedly stealing a backpack from somebody. He claimed he was innocent the whole time. While he was on Rikers Island, he was in solitary confinement for a period of time. He was beaten up by other young people who were there and also by corrections officers. And he didn't have the discovery that he might have needed to fight his case. And the speedy trial laws sort of were another thing in operation that went on there. After 3 years, the district attorney, is that us or no? Okay. The district attorney conceded, admitted, suggested that they didn't actually have contact with the witness in the case. And so 3 years later, they did dismiss the case, and he was released. But he later committed suicide after becoming sort of a celebrity in some ways, right? He was on the Ellen DeGeneres show and things like that. But he later committed suicide, clearly due to the trauma experienced while incarcerated. So if Kalief Browder's case is a problem, well, he was charged with something serious, quote, a violent crime. And he had prior contact with the criminal legal system for an allegation of stealing a mail truck, I think, or maybe an ice cream truck, for allegation of stealing a truck when he was 15, I believe. So here is someone, a young black man who has prior contacts with police and with courts, who's charged with a serious crime and still is detained pretrial. If we think that's a problem, if we think that was unjust, then maybe it's about racial inequality more broadly. Maybe it's about the policing practices that led him to be there. But what it's not going to be is an answer that says we should only detain people who are charged with serious felonies, because he was charged with a serious felony. And then on the left is Sandra Bland, who was charged. Raise your hand if you've seen the video of Sandra Bland being arrested, some people. She was pulled over by a traffic officer, talked back to the officer and was arrested. This police video became a very famous video, but she was then held in on bail, a small amount of bail that she could not afford on a traffic-related offense, a misdemeanor, and she died in jail, probably from committing suicide. So if Sandra Bland represents the problem, then here we might think about racially discriminatory policing practices. We might think about too many cases in the system in the first place, and we certainly might think about setting bail in low-level cases maybe not being necessary for justice. Other problems with money bail that sort of come up, again, one is inequities between how we treat people. One is just thinking about the worry about public safety, having a predator out on the street if you release somebody, and one might be the harms to people and to their families when they're incarcerated. Another might be the broad reach of the criminal legal system in general. Sandra Bland's case, that brings that up a lot. Another might be the cost of pretrial detention. So notice how some of these problems are about money bail, about how unfair it is to treat people differently based on wealth, and some of these problems are just about jail, about pretrial detention and about the need for decarceration. And that split between what you think the problem is going to change a lot what you think the solution is. How does bail reform happen? Again, don't worry too much about the pictures, although I'm going to start with Edith Brown Clement in the middle. She is a very, very, very conservative circuit court judge in Texas, Louisiana, Fifth Circuit. She's in the Fifth Circuit, which covers Texas. And she wrote an opinion in the Fifth Circuit saying that certain parts of the money bail system in Houston were unconstitutional. And so one way that bail reform happens is there is a slew of litigation happening around the country challenging money bail. And it is often focusing on this idea of detaining someone because they're poor, not being fair. And so it's happening under the Equal Protection Clause of all things. You might have learned in con law that equal protection doesn't generally take class or how much wealth you have as something super special. But Edith Brown Clement and most judges who have considered it, including the Supreme Court of California, has said it violates the Equal Protection Clause, going back to an old a series of cases from the 70s and 80s. To take two, she has this passage that my students know about. She says, you take two people arrested for a misdemeanor. One of them has money. One of them doesn't. The one who doesn't have money is going to plead guilty. She sort of implies you might plead guilty because you're innocent, is going to lose a chance, might lose their job, she says, and is going to lose a chance to work on defending their case, and that violates the Equal Protection Clause. So there are some litigation happening, and that's sort of the main way it's happening. There are many others that we are not going to talk about today. It also happens through changing state rules. Maryland's an example of that. I use Maryland as an example of how changing court rules doesn't always lead to change. So in Maryland, the chief judges got together. The legislature was about to pass reform, and the chief judges got together and they changed their bail rules. And the first sentence of their new bail rule says, the purpose of this bail rule is to release more people pending trial. And then it says there should be a presumption of release, and you need to consider how much money people have before you set bail. A year later, there were actually more people in pretrial detention than not, because it had a series of new things, and they started using algorithms to figure out who to release and not to release. And it turned out that more people were in jail. But arguably, the decision was being made with considering whether someone had money or not. So they considered whether someone had money or not, and so it might be different people in jail, but there are more people in jail. Meanwhile, in New Jersey, they actually had to change their constitution to change this, but they took away money bail altogether, much to the chagrin of the bail bonds industry in New Jersey, and they do things entirely using algorithms, which take information about somebody, whether they've been arrested before, whether they have convictions, and whether they've ever had a time where they didn't come back to court. And then they spit out to the judge a level of risk, recommending that they set bail or not set bail. In New Jersey, the jail population has been reduced by about 20% since they made that change, but the racial disparities remain exactly the same as they did before. Then on the right and the top, two other ways. These are judges recently elected in Houston, elected on a platform of saying we are going to set bail in fewer cases. And then on the right, some district attorneys are also running on platforms that they're going to request bail in different cases, because it turns out whether bail gets set depends a lot on what a DA charges and whether they ask for bail. Here in New York City, we'll talk about New York in a sec. So those are ways that bail reform happens. But this is the way bail reform really happens. Is activists working really hard over a long period of time, way before these states were passing legislation, way before these judges were getting elected, way before these DAs were saying anything. People whose family and friends and neighbors have been in jail have been trying to push to abolish money bail, or, note the top poster, end pretrial detention, or build communities, not prison. So there's a movement to not just not put as many people in jail, but also take the money that's saved by the state and invest it in things like education, housing, and other forms of care. Also, there are lawyers. I took this picture of this lawyer, Alec Karakatanis, because of all the law books behind him. So clearly the reporter came and was like, let's sit right there with the law books behind you. I don't think he actually opens those law books. But he is the lead counsel in that Harris County case. So don't want to forget that there actually is a lot of litigation going on and a lot of work between them, right? So this guy is in a room with those guys fairly frequently. Okay. So that's just sort of a setup to talk about New York. As a lot of you know, New York's bail law, actually I think I might have it up here. Well, let me talk. So some of the changes have already happened in New York, I guess is what I would say. So we do have some DA changes, right? So in New York City, at least two of our local DAs, Cy Vance in Manhattan and Eric Gonzalez in Brooklyn, have announced a policy where they're going to ask for bail in fewer cases or charge fewer cases, right? And both of those things are going to lead to less people in jail. Not everyone thinks they're following the policies they announced, so there are court watchers in the courtroom trying to see if that's happened. But they've announced those policies, and there have been some drops in the amount of people on Rikers Island as a result of that. There's also litigation in New York going on. So the New York Civil Liberties Union has brought a case in upstate counties using that Fifth Circuit case to say that bail is being set in violation of the Equal Protection Clause, and they've gotten some initial wins in that case. My class heard from the lead attorney in that case in the fall, and so that's ongoing. But this is really the year, because a lot of what happens in bail turns on what the statute is. And so New York, it turns out, is now the only state in the country that does a particular thing with its bail statute, which that it says when someone comes in, first of all, we have tons of kinds of bail. You could have to pay part of it, you could pay a lot of it, you could use a bail bonds person, you cannot. And judges, for the most part, are not using forms other than using a commercial bail bondsman or setting cash bail. But what the statute says is you can only set bail for somebody in order to ensure that they come back to court. And that's very different than other states in the country, everywhere else, where judges, if they're doing a bail decision, can also take into account, quote, public safety, which often tends to mean the risk that somebody is going to hurt someone when they're, if they've been released and they're waiting for their case to be decided, but has come to mean sort of if someone gets arrested, right? So even just pulled over for a traffic ticket can be a reason. So when we're thinking about what bail reform could look like in New York, there are a bunch of things on the table. And last year, there was a bill from Governor Cuomo that was put out there and never got passed, never even really got put up for a vote. And the state assembly had a bill out there, and they were very different. And so I want to just sort of throw out some of the issues that are on the table in New York as a way maybe to talk more broadly about what's happening. So one of the things on the table is to start to say that judges can detain people if they're worried that they might pose a risk for public safety. So that's one thing on the table. One thing at issue there is what we mean when we talk about public safety. So one definition might be that someone is going to hurt a very specific person who perhaps they've threatened or hurt in the past. That might be one example of public safety. Another example might be a worry that someone is going to be arrested for anything, jumping a turnstile, whatever it might be. And another example is one that's put forth by activists, by groups who are part of community bail funds and post-bail, saying community safety for us means someone not being in jail and in solitary confinement and being home and with their families. Maybe that's a kind of community safety. But that idea of safety is on the table for the first time in thinking about legislative reform in New York for bail. Another big question is, if we get rid of money bail, what do we replace it with? And Governor Cuomo had last year, his proposal did not get rid of money bail. This year it does, almost entirely. He's proposed a law that doesn't have money bail in it. And so if you do that, then what do? I can tell you what he proposed in a second, but one possibility that a lot of states have done is that you get a computer to get an algorithm to give you a scientific reading of whether someone presents a, quote, risk. A risk of what? Maybe that they won't come back to court. Although studies in New York City show that when someone doesn't come back to court, in most cases they do come back to court within 2 weeks. Perhaps they had to go to work or forgot about their court date. But you might look at if someone had a warrant from not coming back to court. You might look at if someone's been arrested, and you might look at someone's prior criminal convictions. And none of those things are going to say, please consider somebody's race. But one of the worries with algorithms is that it turns out actually spitting out an answer that very much takes into account somebody's race, because what your race is and what your class is going to determine whether you have those things that get spit in. So if we think about drug use, for example, think approximately 40-something% of, I have the number here if anyone wants the exact one, of drug users are white, and about 11% of people arrested for drug use are white. So people engaging in the same activities are going to be less likely to end up with those things that you spit into a system. But one question is that better than having judges just eyeball something or make assumptions about someone based on who they are? Another question is, if you get rid of money bail, do you detain anyone? Do you abolish pretrial detention? As you can probably guess, that's not on the table in New York. So then what do you do? Who do you detain? And how do you figure out who to detain? You could use algorithms, or you could look at what they're charged with, but they're presumed innocent. So how do you figure out if they're guilty of what they're charged with before you find out if they're guilty of what they're charged with? How do you find out if they pose a threat of public safety? What should the evidentiary bar be? And should there be a presumption of release? Those are some of the questions on the table. And then, should we be thinking about other things besides that moment? Should we be thinking about who gets arrested in the first place, who gets charged in the first place, speedy trial, discovery, or other reforms that might speed up the process? So here's what Cuomo has proposed as sort of a starting point to think about three things. Here's the first one. This is the biggest thing that's new, actually, this year. And to be clear, what's new this year is that all of New York State is controlled by Democrats. So there's a possibility for passing legislation that did not exist last year. The first part of his bail statute doesn't say anything about bail. It's a rule for police officers that says if somebody is charged with a misdemeanor or a Class E felony, the lowest level of felony, then police officers should be giving a ticket to come back to court instead of arresting someone and bringing them right back to court. Of course, then it lists a number of exceptions to that. And so that's, I can tell you now, a big fight that's going to be there. So if you start to say, well, an exception for that is if someone's charged with anything involving violence, well, violence actually ends up including a lot of things. If you start to say an exception for that is if someone has had a warrant in the past, or if someone has a particular criminal record, then we start to get to some of those other problems. But it starts with the police. Then it says there is no more money bail. And so once you get charged, if you're charged with a misdemeanor, or I think it actually says for all the cases in this one, last time it had some exceptions, the person shall be released, either with nothing or with a series of conditions. And here's going to come another point of contention. There's a whole section about electronic monitoring, and that's something the person who's being monitored has to pay for. And then there's also a section about pretrial services. So that might meet someone sort of like being on probation before you've been found guilty. And then it says, but unless the DA requests pretrial detention. And so if the DA requests pretrial detention, then that person can be held. It doesn't really say how to determine if you hold them right then. So that needs to be added into the statute. And then it says the district attorney has to prove by clear and convincing evidence that the person either is a high danger, I think, or high risk, I have the language here, of not coming back to court, or poses a safety risk to a specific individual. And so that's new from the Cuomo side. That used to be just the assembly language. And so already there are some stirrings from the District Attorneys Association worried about that specific individual language. And there are plenty of stirrings from the advocacy community worried that that pretrial detention part doesn't have something key in it, which is a presumption of release, a presumption that someone does not pose those things, although it does put the burden on the DA. So that's some of the stuff going on in New York. I guess I'll stop there and see if people have thoughts or questions, although I certainly have more details about New York if people are curious.
So, we have a roving microphone, and questions are welcome, or comments, thoughts. Maybe you would hand yours to him.
Sorry, this was great. I can't help but ask a question, though. So when New York is considering requiring people to pay for their own, monitoring devices, that seems like it would violate the same equal protection clause that we have out of the Fifth Circuit. So has there been any thought about that?
So great question. It's a different legal argument, but absolutely around. So if we go to other states that have electronic monitoring, probation that you have to pay for, parole that you have to pay for, and then if you don't make those payments, you're incarcerated. In those states, that same group of lawyers and their allies, lots of lawyers, are starting to win equal protection and due process arguments. So no matter what, this scheme, if it contains electronic monitoring, is going to be open to some challenges. Yeah.
So I know in states like California and New Jersey that have kind of eliminated money bail and they use algorithms and kind of a bunch of different procedures, there's still a lot of issues with their systems and like a lot of racial disparities still exist. And I'm wondering, for you, do you see any ways that like there's language you can build into a statute that remedies those problems, or is it something that is broader than that system and can't be remedied by any universally applicable type of system?
Both. I think both, right? So I, in general, think the system is irredeemable. But as long as we're going to tinker with it, I think that we should tinker with it in ways that lead to decarceration, especially, my goodness, for people who haven't been convicted of anything. So in California, this is a good example. So California passed bail reform this year. That sounds great. First of all, it's now on hold because of a lawsuit from the bail bonds industry. We haven't talked that much about commercial bail bonds, but I'm happy to talk about them. But sort of the predatory nature of commercial bond is also another issue. And one other possible remedy that some states have done is just to get rid of commercial bail and still have bail. So California's on hold, but the fight there, I think, is illuminating in these ways. So initially, there was a statute at issue sort of up for debate in California that was in part written by people on the ground who have been working for decarceration for a long time. It didn't use algorithms. It had a presumption of release for everybody. Those are sort of two key things that the advocates would say were going on. And it didn't have a long list of exceptions for things like the fact that someone should be released. It did, though, have a way to detain someone pretrial with a presumption and a clear, convincing standard, but only for a concern of hurting an individual. So that's what there was. There was broad support for that. But then with lobbying from the DA's Association, and some police unions and a lot of associated groups, the language was shifted a week before it was debated in the state legislature. It took away the presumption, it added mandatory algorithms, and it added lists of exceptions. And so the result is that activists across the state withdrew support, but it was passed anyway. And people were getting ready for actually an increase in incarceration in California, although who knows if that would have been the case. We're going to have to wait. Yeah.
Thanks, Jocelyn. This is amazing. But my questions were more about like the sort of practical realities. I think like a lot of problems in the criminal legal system, pretrial detention, there's some like sort of relatively easy fixes. So one thing is, and I know there were some pilot programs in New York, I'm not sure which boroughs, of like text messages to just remind people to come back to court, had hugely successful rates. And the other thing that used to drive me crazy in practice, and I think still goes on, is that there'd be warrants out for people when they knew perfectly well where they were. They were like at their home, or in my client's case, at one of their parents' home or whatever, and yet the fact that they had an outstanding warrant, which they might not have even known, then would become a risk factor, which would become a problem for releasing them, so on. So there's some pretty easy fixes to that. In fact, recently, some people were talking in my class, I don't think there's a way to even find out if you have an outstanding warrant. At least there's not a way online. Just some easy ways to figure out like which warrants can we close easily, and also like the text message. Is that something that advocates have sort of approached as opposed to having to do litigation and so on?
Yes, and there are sort of two parts to that. One is an underlying issue that is hard to fix, which is that going into those algorithms are all the times that people didn't have a Metro card to get to court and so have a warrant. So we can't fix the problems going back. Which is that a lot of people have warrants because they either couldn't afford to go to court, or they're a teenager and forgot, right? It's a lot of them. And it turns out that, I think I said this, the vast majority of people come back within 3 to 4 weeks in New York City. New York City has implemented pilots and shown that with text messages, phone reminders, and/or Metro cards, the people who come back to court is just a vast difference. And there have borough to borough been changes in that, and that change is coming from the city in part as well, or the Office of the Court Administration. But yeah, there are pushes just to give text messages.
So I'm not totally up to date on this, but when de Blasio introduced a plan to close Rikers and open these jails in each borough except for Staten Island, one of the things that activists were saying was if we just ended pretrial detention, we wouldn't need the amount of space that you're trying to open in all of these jails in each borough. And while that fight is happening at the city level, I'm wondering how much communication there is while all of this talk about pretrial detention and bail is happening at the state level.
Yeah, so the activists, the coalitions who are pushing for change at city and state. So that's, I think, almost the biggest source of communication. De Blasio, frankly, has been all over the place in talking about bail on its own. He recently made a speech asking for more bail. But he has called for closing Rikers Island and has a plan to do it. And the way, as you said, the way the plan would work is that Rikers would be closed. I want to say 10 years ago, the population at Rikers Island was around 19,000, I think, per day. As you saw in there, it's now 8,000, right? So that's lower. I think it was 12,000 as recently as 4 years ago. So it is going down. But de Blasio has said that he wants to get it down, I think, to 5,000. He's declared that the number. And if it's going to be 5,000, then there needs to be more jail beds. So the proposal is to build new jails in the Bronx and Queens and enlarge jails in Manhattan and Brooklyn. And so there's been a lot of pushback on that number. But I'm on the community advisory panel for the Brooklyn changes. And between all of us and the video recording, every time they they're very clear that when they're calculating their 5,000 number, which does shift, they are putting into their computer estimations of what the bail reform statute will say and what it will mean for incarceration. So they're taking it into account.
So in terms of New York, because it's a political legislative solution that's kind of being put forth, is there any fear that there's going to be, 2 steps forward, 10 steps back when, God forbid, somebody is released on bail and they're, the one minority person that does go on and commit a violent crime, and then, like these things escalate, like a Willie Horton situation, and what's being built into the legislative solutions to kind of prevent this from snapping back further than where the situation was before?
Yeah, so it's a great question. So Willie Horton was the situation where after, in Massachusetts, there was a state reform to, I think, allow furloughs when people were waiting for parole, and Willie Horton was on a furlough and committed a heinous violent act, the details of which I forget at the moment. Dukakis had been the governor, so this led to sort of nationwide advertisements about that policy. It's going to happen. It's going to happen. So in one of these states, or in New York sometime soon, that's going to happen, and there will be press about it. A couple of things on that. First of all, it actually has happened. So it's happened in New Jersey, it's happened in Kentucky, and they're doing fine. In part because, and I don't know the details of it, but there have been pushes by the bail bond industry. When the bail bond industry is watching every single case, and whenever anyone does anything, they the equivalent of the New York Post publishes something. So it happens, but the battle is in changing the narrative around that before it happens. So one example, this year, and now my crim students who are here know about this one, there was an action led by Kerry Kennedy, She actually had been prosecuted in the past, was really frustrated. She went to trial. She got acquitted. She made a speech about how if bail had been set and she hadn't had money, she wouldn't have been able to go to trial. So she has taken a lot of money and invested it into decarceration and reform of the criminal legal system. And one of the things she did this year was a mass bailout. And I mention this because this came up. So she said, and it's not just her, she's working with a lot of community groups. So these groups came together and they said, in this month, we are going to post bail for every woman and child on Rikers Island, which is a lot of people, thousands of people, if you count people 18 and younger. And they were thinking it would be about 500 people. It ended up being fewer, but the press went for New York City, wild, right? Cover of the Post, or maybe the second page of the Post, saying, criminals are going to be let out on the street. Just you wait. It's going to be a public safety nightmare. DA Clark and the Bronx, all the DAs had a quote along those lines. They're really worried about their victims. They did bail out hundreds of people. You know what? Everybody was fine. Everybody was fine. Did some people get rearrested? Yes. Did anybody get hurt? No. And there have been one or two, so even the New York Times published an article saying, it was like the headline, DAs are worried about public safety with this Kennedy initiative. They never go back and write that second article that says, the DAs were worried about that initiative, but it turns out lots of women went home to their families. And so maybe if we did a public safety calculation, public safety went up. Even though people were charged with homicide, some of the, really, really serious crimes. So it's about changing the narrative, but it's sometimes hard to get the press to change the narrative.
Joyce, what's your ideal solution if you were king?
Can I be queen? Okay. So my ideal solution would be to look beyond the specifics of money bail and not put most or all cases into what we have constructed as the criminal legal system altogether. And so, given that that's my solution, I find bail reform discussions both exciting and frustrating because so much gets embedded into what you talk about. So if you start to say, wait, but people who are violent should be detained pretrial, well, then I want to have a long conversation with you about what violence is and how we decide who's violent or not, et cetera. All that said, if the New York could pass the current assembly bill that's been proposed by progressive members, it's the same one that was proposed last year, I think that would be a wonderful thing for New York State and would lead to decarceration. And that's a bill where there's no money bail, a presumption of release for everybody, and very narrow circumstances where you can have pretrial detention. That's not my solution as queen, but that's my I don't know, statutory New York solution if I'm queen. Yeah.
Jocelyn, can you talk a little bit about the predatory nature of the
Bail bonds?
The bail bond?
Yeah, so are any of my bail bond pro bono folks here want to talk about it? Is that Oren's hand? I can't see. Any chance you want to talk about the predatory nature of the bail bond industry? No, okay. We have a group who's worked on doing research. They actually went around taking pictures of bail bonds, the addresses where bail bondsmen claimed that they were, and then they went to those addresses and took pictures and they were not there. So this is in New York State. So the way the bail bond industry works is they come to somebody in the most vulnerable moment of their life, right? Someone says, my son's been arrested. They say, I need $10,000 bail. And the bail bondsman person says, okay, you only have to give me 10% of that. And I'll go free your loved one from jail. And so that is, in the moment, a good thing. When you do that, though, you have to give some kind of collateral for the rest of it, which you would lose if the person doesn't come back to court. And on top of that, there's a fee that you don't get back. And there's a statute making limits on the fee. But if you look at practices in New York State, bail bonds, people are going way above what they're supposed to. So in actuality, you might, in that transaction, have to pay, they might make you pay in addition $300 that you don't get back for using the bail bonds person. So that's why it's a money-making business, because it's a predatory thing, and once you take money at the time when someone's incredibly vulnerable, and then you never get that money back, even in the best circumstance. And then the worst circumstance is a lot worse, because warrants get issued and bail gets revoked for things that sometimes are within someone's control and sometimes aren't. And so then you lose all of the money. Because it's such a profitable enterprise, though, the bail bond industry is incredibly wealthy. And the wealth actually doesn't just come from the bonds people, it comes from the insurance companies who insure the bonds people. Color of Change actually did a report on this. It turns out the insurance companies are making the most money on the insurance bond industry, on the commercial bail bond industry. So altogether, that leads to a pretty big lobby in favor of bail reform, against bail reform, I mean.
Just, you explained this to us last year in the bail fund group, but I think it's worth mentioning that there's a limit on how much like charitable organizations can pay when they pay bail for other people because of the influence of the bail bond industry.
Yes. So community bail funds, I don't think I've even really talked about, exist in New York State. And this is a thing where a charitable group can register with the state, and then they can post bail for people they don't know, for strangers. And this could be a really powerful thing, because when they are doing that, they're saying, traditionally it's someone's mom, and so they put their money up because they love that person. But here it's people who are just people, just citizens, just community members, citizens with a little c, saying, we think that life is better, and as a community we're safer when people are not incarcerated pretrial. And so there's been a big movement. Community bail funds have really proliferated throughout the country, and they're freeing people, but they're also switching the narrative around money bail in some of the ways we talked about. And New York is one of the states where they really started their growth, but a judge shut them down, and then they had to change the legislation to make charitable bail funds legal. And when they did that, they negotiated it, and the bail bonds industry was very much against this legislation, as were every arm of law enforcement, because public safety. And as a result, the limit is that bail can only be posted by charitable bail funds for misdemeanors, and it has to be less than $2,000. And so one proposal on the table, which is actually a separate bill, is also to remove some of those limits. But if there's no money bail, you don't need to. Yeah.
Great. Other comments or thoughts, suggestions? Aha, yes.
I'm sure it was already touched on, but may I ask, how do you all feel about the red herring of the dangerousness that a lot of proponents against reforming the bail system like to throw about? For example, someone may be confined on a gun charge, and prosecutors only, and it might be their first charge or something, and the prosecutor's only argument against that may be there's a dangerous element to this felony, so therefore they should not be released. How do you feel about that?
Yeah, so we have talked about a little bit. I'm frustrated by it, as you know, but I think that one isn't hopeless. This is the Willie Horton problem. I think this is about changing what we mean by dangerousness. Kalief Browder is one of these examples that really his name has taken hold as standing for why juveniles shouldn't be in solitary confinement, any number of why pretrial detention might be unjust. But if we stop, I think at any moment anyone's interested in bail reform, they should stop and ask, what would have happened in Kalief Browder's case? Because he was on probation for stealing a truck, serious felony, stealing a truck, and he was charged with a violent felony. The violent felony was I think he had a co-defendant, was made it, two kids together taking a backpack off of somebody. That's robbery in the second degree. So I believe the co-defendant was not on probation and didn't have bail set. I don't know for sure how that case ended up. But the point being, he was a dangerous felon. He was a dangerous, dangerous person. He was presumed dangerous. It turned out he was actually not guilty. But what if he was? What if he had taken a kid's backpack? Does that mean that pretrial, that the violence... Think about the violence he endured. Does that mean the violence that a kid endures in jail is worth the risk that they might take someone else's backpack? I think that's the conversation we need to have, not just Kalief Browder was innocent. But let's face it, I'm not even sure we know 100% he was innocent. I don't know. I don't think that's the main issue. What if he had taken a backpack? Sort of changing the narrative about what it means to be dangerous, I think, is a big part of this.
So can I ask you a question just following up on that? And this will be the last comment because I know classes may start again very soon. But it slightly broadens the perspective from bail, but to the point you're making of changing the narrative. So Larry Krasner in Philadelphia, the progressive DA, is famously known for something which I think is happening less than the New Yorker magazine reported, but for asking his DAs to go into the courtroom, and every time they ask for a prison sentence, to talk about the amount of money it will cost society and how that money could be used for schools, etc. And I just wondered if there are other examples of those kinds of efforts to change the narrative that you know about.
Yes, they are, and this is the narrative that's being changed on the ground. So when you're looking at social movements, really in almost every state, who are starting to think about decarceration or how do we end mass incarceration, and this does go beyond bail. One narrative is, let's end mass incarceration, period. That starts to give us concerns about, okay, well, what happens to these people? What's gonna happen? Even if we save money, what about the danger? Another narrative is decarcerate, divest from using the criminal law to solve problems, and then invest in the same communities that you might be worried about in other ways, like education, housing. So Krasner is essentially using the invest, divest mantra that social movements have been using for quite a few years, including the movement for Black Lives. So that's, I think, where and again, if I'm queen, you're not just divesting, you're investing. Yeah.
Great. Well, I'm sorry to draw this to a close because I know there's so much knowledge and information as well as passion up here. But would you join me in thanking Jocelyn Simonson for coming?